Civil procedure. Civil procedure deals with what we call procedural law, or the how of the law, as opposed to substantive law, which deals with the what of the law. So let's take a look. Procedural law deals with, well, how do I go about getting compensated for a breach of contract? How do I file my lawsuit? How do I contest a will? How do I go about getting an injunction against somebody if I need an injunction? Now, that's all examples of procedural law. Substantive law would deal with things like, well, what is a contract? What is a breach? What sort of damages can I get? What are the requirements for a will to make it properly executed? What is an injunction and who's entitled to it and when? That's substantive law. Procedural law, civil procedure is what we call procedural law, and so that's what we're talking about today. Let's look at some basic terms. Jurisdiction. Jurisdiction is the power of a court to decide a case. And jurisdiction is broken down into several different aspects. The first of these is there's a geographical aspect of jurisdiction, that a court would only have power over things that happen within its geographical area. The next one is personal jurisdiction. A court only has jurisdiction over people who appear before it or who are subject to its control. And so it's generally thought that a court has jurisdiction over people who reside in that area. But what about a non-resident who is sued? You know, it's not a problem if the non-resident comes into the court to file a lawsuit against a resident, because the non-resident has subjected themselves to the jurisdiction of the court. But what about a plaintiff suing a non-resident? Well, sometimes that is allowed, and that's where we have things called long-arm statutes, laws that say when a non-resident is subject to the jurisdiction of a court. And then, of course, we have subject matter jurisdiction. And subject matter jurisdiction deals with the concept that not all courts can hear all kinds of lawsuits. Certain kinds of courts can only hear small matters dealing with small amounts in controversy. Some matters can only be heard by some courts, like death penalty cases can only be heard by more superior courts, or what they may be called district courts. An eviction case in many jurisdictions can only be heard by a lower court, like in Texas, by a justice of the peace or a justice court. Then we also have this concept of venue. Venue is simply place. Where is the lawsuit filed? You may have a district court, district courts in different parts of the state that can have jurisdiction over a type of a lawsuit, but there may be just one place where it really should be filed. And of course, if there is bias in that place, someone may ask for a change of venue to another court that does have jurisdiction, but just in another place. And then, of course, adversary system. And that's getting at the concept of what our system is all about. It's a system in which adversaries, a plaintiff and a defendant, go to a neutral forum presided over by a judge to fight over, in a civil way, their dispute, to try to have the dispute decided in their favor. And the idea is that if both the plaintiff and the defendant put on their strongest case, then out of that will come the truth, a resolution. Now, as we do that, though, we have to follow rules of procedure. And in Texas, we have something called the TRCP, the Texas Rules of Civil Procedure, and there's a counterpart called the Federal Rules of Civil Procedure. And then when it comes time to presenting evidence to the court, that's how we present our case, well, we have rules there too. And in Texas, we have the Texas Rules of Evidence, and then there's the counterpart, the federal counterpart, the Federal Rules of Evidence. And these rules of evidence deal with things such as, well, what is admissible? What is admissible here evidence. What is this notion of hearsay? We always hear about hearsay evidence. What is hearsay? What is privilege? What does it take to authenticate a piece of evidence to show that it is reliable and that we can use it in court? We also have the term called pleadings. Pleadings. The plaintiff files a pleading called a complaint, or in Texas we call it a petition. And is filed by the plaintiff. It describes the cause of action, and which is another word for the lawsuit or the type of claim that we have. The defendant will file an answer to explain the defendant's point of view. It's filed by the defendant to contest the lawsuit. It sets out the facts that the defendant disputes. And if the defendant has any affirmative defenses, the defendant will point those out. An affirmative defense is kind of like a trump card in a card game. It's a defense that will trump or defeat anything that the plaintiff says in their case. And if the defendant does not file his answer or her answer within the stated time, then they're going to be losing the lawsuit in what we call a default. How does the defendant learn about the lawsuit? Well, that's what we call service of process. That's the legal notice that's delivered to the defendant. And it's delivered by a constable or a sheriff or a private process server, or maybe even in the federal courts and the federal system, it may even be served by a federal marshal. Let's look at a timeline now of a lawsuit. I've put up here, we have an event which could be the breach of contract or an accident, followed by the plaintiff files a petition in court. The petition is served on the defendant, giving them notice, and then the defendant needs to file his answer. Following that, we have this period called discovery, and that's where both parties, through their lawyers, if they have lawyers, gather evidence in preparation for trial. And you can request evidence from the other side. But this period of discovery takes up most of the timeline of a lawsuit. How do we gather this evidence? Well, we take depositions. A deposition is a questioning of a witness under oath in front of a court reporter. The lawyers are present and ask those questions. We also have interrogatories where the lawyers will send to each other or to their clients, opposing client in the case, questions. And these are written questions that have to be answered under oath. And they only go to a party. Party has to answer those under oath. We can also ask a party, an opposing party, to turn over certain documents and things. Credit card bills, contracts, correspondence, letters. I even had the opposing party turn over a shotgun one time that I wanted to have examined. So we can have requests for productions and things. That's very helpful in developing our case. Then we have requests for admission, and that's where a party will ask the other side to either admit or deny that certain facts do exist. And when you do that, that does have a tendency to narrow and maybe shorten the case a little bit and what has to actually be put on trial. Now, during the trial or during the case, during that timeline, from time to time, one party or the other, or maybe both parties, will be asking the court for certain decisions, certain guidelines, guidance for the conduct of the discovery, maybe to asking the court to, judge, this is a worthless case, pointless case, it's frivolous, please dismiss it, here's my evidence, to show that there is no evidence on the other side. Or they may be asking the court to step in and help with the scheduling of depositions or other events. So there'll be motions and orders that the parties will file from time to time. The motion is where the party requests what they want of the court, the relief, and the order is a document that the court signs, either granting or denying the relief. Sometimes the court will have a hearing, sometimes they won't. And finally, let's put all this together now. We have our event, the plaintiff files the petition, defendant is served, defendant files an answer. And then we have this period of discovery. And finally, at the end of this period of discovery, the court's going to say, okay, lawyers, clients, come on in and let's have a pretrial conference and plan this trial out. So that's a pretrial conference, and that happens right before you go to the trial. Then you do have a trial. Trial could last just anywhere from just mere minutes, I've had that happen, to weeks and maybe even months. Y'all have seen that on TV. And then after the trial, a decision is made, and then we have a judgment and then appeal. Let's look at the trial a little bit more carefully now. Trial starts, if it's a jury trial, with something we call voir dire, or that's what we call it in Texas. Other lawyers from other states pronounce it voir dire or something like that. But it's jury selection. And then after jury selection, we have the plaintiff putting on the plaintiff's case with their opening statement, and then after the opening statement, calling their witnesses for direct examination by their own lawyer. And then the other parties in the case can cross-examine each of those witnesses. Once the plaintiff has put on all of their witnesses in evidence in that way, then it's the defendant's turn. And then the defendant can make an opening statement if they already didn't make one over here. And then the defendant calls their witnesses one by one for direct examination and then cross-examination by the plaintiff. And then at some point the defendant will rest, just as the plaintiff had rested earlier. There may or may not be something that I didn't put on the chart here called rebuttal evidence, where the plaintiff can come back and rebut some things that maybe the defendant may have put on in evidence. And then once all that evidence is in, then it goes to the jury. The judge has to give the jury instructions, and then at some point there'll be a final argument by the lawyers on what they had presented to the jury earlier, trying to help the jury make some sense of all of this evidence. And then the jury goes back and deliberates. And after they deliberate, hopefully they come back with a verdict, a decision. And the judge will take that decision and instruct the lawyers what that verdict means and turn that verdict into a judgment. And typically the winning lawyer drafts the judgment. And the judgment is the last document filed in the case, typically, and that ends the case, and it says who wins and who loses. So you begin the case with the petition or complaint, depending on your system you're in, and you end the case with the judgment. And then, of course, there can be appeal after that. And that is an overview of civil procedure.